Welcome to the other side of Lucy Letby. In episode 58, we will continue with the Court of Appeal ruling that denied Lucy Letby the right to appeal the murder and attempted murder convictions that she was accused of. And I think we left off at paragraph 131 in his ruling of 2nd of May 2023, rejecting the submission of no case to answer. The judge referred to the passage of R v Galbraith, which we have quoted above, and to the competing arguments of the parties. He expressed his conclusion and his decisions as follows in paragraph 13 of his ruling. And this Galbraith ruling states that, amongst other things, the difficulty arises where there is some evidence, but it is of a tenuous character, for example, because of inherent weakness or vagueness, or because it is inconsistent with other evidence. And then the answer to this riddle is A, where the judge concludes that the prosecution evidence taken at its highest. Now again, I'm really confused here. The duty of the expert witness is to the court. Any expert evidence that's admitted into evidence should be the same, no matter who gives it. So anyway, where the judge concludes that the prosecution evidence taken at its highest is such that a jury properly directed could not properly convict on it, it is his duty, on a submission being made, to stop the case. Well, it's my argument that the evidence given by these experts is wholly inconsistent with other evidence, the other evidence being the many papers, case descriptions, case series, case studies, prospective analyses, and therefore common knowledge in the practice of medicine that prove to a reasonable standard that 90% of our emboli occur as a result of complications of treatment in a preterm neonate, whether that's ventilation or central venous lines, and that we have no way of separating one from the other with any great deal of certainty, or at least not to a standard we would expect to provide when we're making any diagnosis in medicine. In other words, the diagnoses of our emboli in these cases are weak, vague, and tenuous. And on that basis alone, it's my opinion, the case should have been stopped. On the basis, too, that the babies were stable. The evidence that the babies were stable, given during the trial, but misinterpreted by the experts or over-interpreted by the experts, didn't indicate that the babies were stable. There is no guarantee or high expectation that anyone will recover from CPR, and that in particular in preterm babies, as we've already established, about 90% of babies who undergo CPR will have evidence of our emboli by the gold standard method of diagnosis, CT scan, after CPR. That neither postmortem x-rays nor histology are a sufficient method by which to diagnose our emboli, mainly because neither of those two methods can determine the nature of the gas. Dr. Manarides couldn't say that the microscopic bubbles he's seen on histology contained air or putrefaction gases, and therefore it's pretty useless evidence. And the same for Professor Arthurs. And we know now for a fact that these judges and the jury did not have all the information they needed to reach a conclusion. For instance, the overventilation of baby O, baby P, and the liver injury to baby O. So, in my opinion, the case should have been stopped. The evidence was rubbish. And then Judge Galbraith goes on to say, B, where, however, the prosecution evidence is such that its strength or weakness depends on the view to be taken of a witness's reliability or other matters which are generally speaking within the province of the jury, and where on one possible view of the facts there is evidence on which the jury could properly come to the conclusion that the defendant is guilty, then the judge should allow the matter to be judged by the jury or tried by the jury. And let's look at the wording of that again, because it's really important that the strength or weakness of the evidence depends on the view to be taken of a witness's reliability or other matters which are generally speaking within the province of the jury. But these expert witnesses are cherry-picking evidence, and they're using prejudicial and, in my opinion, misguided interpretations of the evidence. And more importantly, they're not using all of the evidence. And therefore, I argue again that if you don't give the evidence at its highest, then the jury can't take it at its highest. In common sense law, what's the point in having an expert witness in a trial? To give you information and evidence about which the jury know nothing. If you're then having to ask the jury not only to weigh the relevance of the evidence, but also the reliability of the evidence, I will argue that that is a logically impossible task. And I would argue that mainly because since Letby changed her defence team and the Thirlwell inquiry got going, we now have a completely different picture emerging of what happened to each of these babies and their families at the Countess of Chester Hospital, and it's very far from what the jury was told and the judges were told, and more importantly, the families during this trial. In my opinion, I'm not a lawyer and I don't care. I have an opinion. In my opinion, this Galbraith ruling should have been applied and the case should have been dismissed. Returning to 131, I am satisfied that there is a sufficient body of accepted expert medical opinion that the exogenous administration of air into the venous system can cause air embolus, leading to collapse and potentially death in a baby. Absolutely no question that that is true. But to draw a conclusion, or in other words, make a diagnosis of air embolism, not air embolus, requires the use of methods that were not used in this case. And therefore, no baby in this Letby series had even close to an acceptable diagnosis of air emboli. This evidence indeed wouldn't have been enough to win a civil case for negligent causation of an air emboli. But the evidence would easily reach a civil standard for litigation for negligent care in every one of the cases. And then the judge carries on, because of the rarity of cases in which air embolus is identified in a fatal collapse, there is limited medical literature and research, and the level of clinical expertise is also necessarily limited. And again, I argue that is so far from true as to be laughable. We know exactly how, when, where, why, and to whom these air emboli occur. The medical literature is not limited to the 19 papers presented by Dowie Evans. It goes much wider than that. Professor Arthurs and Dr. Mararides were conspicuously careful not to go further than their specialist expertise would permit them, and emphasised any conclusions to be drawn were for those with clinical expertise. But that's not true either, because radiologists play a very important and central role every day in the practice of clinical medicine, and it is well within their capability to diagnose air emboli in preterm neonates, but not with x-rays, unless, as Professor Owen Arthurs said himself, you actually get a photograph of air in the heart and the great vessels at the time of the air emboli and not post-mortem. That is the only radiological x-ray evidence of any use. Or, in other words, it's evidence at its highest to infer that a patient has or had an air embolism. And I believe that Professor Arthurs made that statement, but the judges and the jury, not understanding what it meant, have misinterpreted that statement. During post-mortem and on CT scans, it's very common to find things that you're not looking for, and you then have to assign them relevance in your findings. You look at an x-ray of a preterm baby or a term baby, baby D, and you find that the baby is down to 50% of its lung capacity because of pneumonia and the effects of pneumonia. That baby subsequently collapses and dies. There is no need then to go looking for air emboli as a rare cause of death, because you have on your plate one of the most common causes of death in preterm neonates, pneumonia with sepsis. And then we get a stunning statement from the judge. The fact that Their evidence was not of itself diagnostic of our embolus, is not determinative as to whether the evidence of clinical neonatologists is admissible. How does any doctor make a diagnosis of a disease? By the use of expert evidence, either their own expert evidence or that of their colleagues. And the truth of the matter is that more diagnoses are discarded in clinical practice because of lack of evidence. No one ever makes a diagnosis on a patient for which the evidence is vague, tenuous, or uncertain. That, by its very definition, is a differential diagnosis. And the nature of a differential diagnosis is that it is tenuous, often vague, and uncertain. And being so, a clinician should not get dragged into reaching bizarre conclusions before any structure is put in place, the serious from the not serious differential diagnoses. But we have to remember how we got here. We got here not by the conventional use of clinical medicine. We got here after one man, Dowie Evans, considered other causes of death for these babies than the causes of death already established by postmortem. He tried noxious substances first, and then he came up with our embolism, while ignoring all the contrary evidence of the postmortem findings. That's how we got here. Then we had Dowie Evans take part in an investigation, in fact lead an investigation that would prove his hypothesis correct, not by any recognized scientific methods, but by stringing together circumstantial evidence and non-specific findings, and willfully discarding vital evidence that should have sent him in a different direction. And the judges carry on such criticisms as are made by the defence of Dr. Evans and Bohan, and the basis for their conclusions are not sufficient to render their evidence inadmissible. Their evidence, therefore, is admissible in a criminal trial, but it wouldn't be admissible on a ward, and more particularly in the circumstance of a professional examination. The assessment of the validity and the criticisms and the weight to be attached to their opinions is for the jury. By that logic, then, we don't need external examiners to ensure that our doctors are competent and reliably knowledgeable. We can get any 12 people from the street to do that for us. The judges continue bizarrely in the context of other circumstantial evidence, including the fact that in the cases of 2 other babies not the subject of these applications, someone in the neonatal unit deliberately sought to harm them by adding insulin to their nutrition, and the circumstances and coincidence of the defendant's presence in the unit on each of the occasions of the sudden collapse of a baby, which is simply not true. The babies collapsed frequently when Lucy Letby wasn't there. In some cases, Letby was at the cot or the incubator side, which is where you would expect a nurse to be if a baby had collapsed. The juvenile circular logic of these people is astonishing. And her admissions, well, from what I've read, all of her admissions are, I never harmed a baby. But the judges are satisfied that the evidence sought to be excluded is admissible expert evidence for the jury to consider. I am also satisfied that in respect of counts 1, 2, 4, and 16, there is a body of evidence on which the jury, depending on their findings of fact and the inference they draw, could properly come to the conclusion that the defendant is guilty. The jury were never properly given the body of evidence available to any doctor on the true nature of our emboli. And therefore, any inferences that they drew, albeit in good faith, were automatically incorrect. Similarly, I refuse the application that the evidence of our embolus should be withdrawn from the jury on counts 3, 5, 12, 17, and 20. And this is a perfect example of a little knowledge being a dangerous thing. The jury were given a little bit of knowledge about our emboli, but they didn't have its nature properly described to them. And they weren't told that really no doctor could draw any conclusions from this evidence, because truly it is too vague, tenuous, and non-specific to be accurate, and they wouldn't want it used on them in their own life. So we've got to paragraph 132. without really learning anything new. But we're now on ground 2, the submission to this court. Paragraph 132, in the present application, Mr. Mera submits that for the reason which he argued unsuccessfully before the judge, the submission of no case to answer should have been allowed. Perhaps if he had put somebody with a bit of common sense in, like Professor Michael Hall, for example, who could have told the jury, yes, all of this is possible. Everything that Darry Evans and all these experts, everything that they've said is possible. But it's not the type of evidence that we would use in everyday practice. And it's certainly not the type of evidence sufficient to make a finding of guilt in a murder trial. There, easy. He accordingly, that's Mr. Mera, submits that the judge fell into an error in this ruling, that as a result of that error, the convictions on the counts for which the submission was aimed are unsafe, and that all the convictions of other counts, counts 6, 7, 18, 15 and 21, are also unsafe, having regard to the judge's direction to the jury on cross-admissibility. Paragraph 133, Mr. Myers points out that it was never in dispute that our embolism can be a cause of collapse or death. The issue, he contends, relates to whether the evidence showed a sufficiently reliable basis to permit a diagnosis of our embolus in neonates. No, it does not. And that is not how we practice medicine. He emphasises, that's Myers, that his submission is not concerned with the evidence relating to the allegations of our embolism in specific counts. Rather, it is a challenge to the reliability of the scientific knowledge supporting the theory and diagnosis of our embolus. And he invites the court's attention to passages in Orr versus Holdsworth and Orr versus Dlugosch, Orr versus Dlugosch, to the effect that the court must be satisfied that there is a sufficiently reliable scientific basis for expert evidence to be admitted, which is precisely the wrong argument. Of course, there is enough evidence to determine whether or not an embolism was the likely cause of death. There is more than enough method and knowledge to do this, but not in this case. Let's have a look at these two rulings. In the Holdsworth case, we have another woman convicted of murdering a child, and there were 5 expert witnesses, I think, in the trial, and none of these spoke for the defence of the mother. Suzanne Holdsworth appealed. New evidence was put to the judges, and this new evidence suggested alternative explanations for Kyle's death, and ultimately the conviction was quashed. So it looks like we've already learned this lesson before, that expert witnesses can give misleading information not intentionally, and that juries not intentionally can misinterpret the information. But when an alternative explanation is put to them, they can change their mind. And the Dlugosch case is very similar. Mr. Dlugosch was convicted of burglary, robbery and manslaughter at the Central Criminal Court, and the case involved the death of an 83-year-old lady found at the scene of the burglary. The only forensic evidence found was a very small quantity of DNA on 2 pieces of evidence. The DNA evidence was low template DNA derived from a mixed sample. That would be the equivalent of post-mortem X-rays. And the main issue at the appeal was the admissibility of the expert DNA evidence. And the judges ruled that the evaluative opinions based on an expert's experience were admissible, even without statistical evidence, but that the expert had to explain to the jury that there was no statistical basis for his conclusion, and therefore the opinion should be presented as limited assistance, different from typical DNA evidence with statistical probabilities. And that would be equivalent to a CT scan as opposed to an X-ray, particularly a post-mortem X-ray, and also a non-specific rash, and the likelihood that a baby who undergoes cardiopulmonary resuscitation has a 90% chance of finding error in the great vessels in postmortem x-rays. And this case was important because it emphasized the importance of clearly explaining the limitations of evidence to the jury. But the judges in the Letby appeal doesn't think this applies to the Lucy Letby case because for some bizarre reason, they think that everything that these expert witnesses said is typical of everyday medical practice, when it isn't. It's extraordinarily atypical of everyday medical practice. And they carry on. He also relies on what is now paragraph 713 of the Criminal Practice Direction 2023, which states, in addition, in considering reliability, and especially the reliability of expert scientific opinion, the court must be astute to identify potential flaws in such opinion which detract from its reliability. For example, being based on a hypothesis which has not been subjected to sufficient scrutiny, including where appropriate experimental or other testing, or which has failed to stand up to scrutiny. B, being based on unjustifiable assumption. C, being based on flawed data. D, relying on examination techniques, methods, or process which was not properly carried out or applied or was not appropriate for use in the particular case. Or E, relying on an inference or conclusion which has not been properly reached. So where the hell do you start with this? Being based on a hypothesis which has not been subject to sufficient scrutiny. For example, death by air administered to a nasogastric tube has no empirical or inferential data or description anywhere in the medical literature. Lucy Letby is the first person on planet Earth convicted by a court of law for causing death by that method. If that's not a hypothesis based on insufficient scrutiny, I don't know what is. Being based on unjustifiable assumptions. That would be the entirety of the pink flitting rash description. The judge's conclusion from Dowie Evans' evidence that air embolism is a diagnosis of exclusion, which it most assuredly is not. Or Dr. Bowen's use of the term grey-blue, GRAYEYBLUE, as a serious description of skin discoloration in these babies. And I would have to say too that the evidence of Professor Lee is misleading as well, in my opinion. And that would fall under the category being based on a hypothesis which has not been subjected to sufficient scrutiny. Dr. Lee, or Professor Lee, claims that the pink flitting rash, which he refers to as Lee's sign, was due to the direct oxygenation of hemoglobin in the vasculature from the oxygen in the air emboli themselves. But sadly, Professor Lee doesn't have any evidence for that. There's only ever been 2 cases, and this claim has never been subjected to sufficient scrutiny and can just as easily be a trick of the light. It's also, in my opinion, the erroneous case for all of these babies based on an unjustifiable assumption that because people said they were well, that they were actually well. And the flawed data, nearly every biometric measurement taken on these babies was flawed, as we've explained before, from oximetry through to bedside glucose measurements. The method of diagnosis by exclusion, is not an appropriate method by which to reach a diagnosis in 2023. And relying on inference or conclusion which has not been properly reached is, in my opinion, the entirety of the medical evidence against Lucy Letby. And in paragraph 134, Mr. Mera submits that the level of scientific knowledge did not provide a reliable basis on which to make a finding of air embolus in any individual case. In particular, although witnesses described very unusual skin discoloration on the babies concerned, those descriptions did not provide a reliable basis for diagnosis of aortic embolism. In this regard, he argues the reliability of the expert evidence was not a matter for the jury. Rather, it was a condition precedent or precedent to the admission of that evidence. The expert evidence on which the prosecution relied to prove the allegation of aortic embolus should therefore have been ruled inadmissible. But he's wrong on that argument by the rulings in the Dulglosh patient that he actually quoted. Appeal court judges have said that it is okay to put in evidence that is not absolutely conclusive. That was the substandard DNA test, provided that you tell the jury that the evidence isn't that good. And all of this evidence, so-called medical evidence against Lucy Letby, is in that category, subpar DNA, because you can do proper DNA. And in cases of aortic embolism, we can do proper studies, CT scans, specific autopsy techniques that are the equivalent of high-grade DNA evidence, but which no one carried out on the Letby babies. So in that sense, it is exactly like the Dulglosh case, except that the argument was that the evidence was admissible, but it was substandard. And things get even worse for Letby in 135, paragraph 135. It may be noted that in written grounds for appeal it was argued that the Lane-Tanswell papers should not, and that's underlined, have been relied upon as it was by prosecution witnesses. The paper was said to be of little application to the trial of the applicant. It was not designed to explore the link between aortic embolism and skin discoloration, with discoloration being noted in only 5 or 6 of more than 50 cases of aortic embolism. Collapse reviewed, only one of which was bright pink vessels against a generally cyanosed cutaneous background. Moreover, the subjects of the Lane-Tanswell paper were not comparable in age, medical condition or clinical circumstances with the infants concerned in this case. It was submitted that the paper, therefore, could not support the evidence of prosecution witness to the effect of skin discoloration is a feature of aortic embolism. But again, that's entirely the wrong argument. The babies in the Lane-Tanswell paper were in exactly the same category of patients as the Letby babies, but the Lane-Tanswell paper refers only to pulmonary vascular aortic embolism, which is a distinct pathological classification or disorder from venous aortic embolism, and should have been excluded, therefore, on those grounds alone. There wasn't a single case of venous aortic embolism in the Lane-Tanswell paper, not one. And if the Lane-Tanswell paper was used by these experts as it was, then the assumption should have been that all of the babies had pulmonary vascular aortic embolism, because that is the only type of aortic embolism described by Lee and Tanswell. And that would not include Lucy Letby injecting air into the peripheral circulation. And this whole argument back and forth tells me that in spite of their best effort, the defence didn't understand the nature of this case either. And in 136, paragraph 136, things get even worse, because Mr. Myers has now changed his mind. In his oral submission, Mr. Myers now, however, argues that the specific skin discoloration mentioned in the Lane-Tanswell paper can properly be treated as diagnostic of aortic embolus, but that no other type of discoloration can be regarded as diagnostic or pathognomic of aortic embolism. So it's very clear what Mr. Myers is doing now. He's agreeing with Dr. Lee, who he has all too late taken on board, that the so-called Lee sign is pathognomic of aortic embolism. And Mr. Myers goes on to say that the prosecution expert evidence provided neither a research basis nor clinical experience sufficient to enable reliable identification of any specific cutaneous discoloration which would be diagnostic of aortic embolism. And sadly for Mr. Myers and Lucy Letby, that is also true of so-called Lee sign. There is no scientific basis to make the claim that the Lee sign is pathognomic of aortic embolism, because it's an attribution, a hypothesis, that's based on something as flimsy and unreliable as human perception of colour, which is not dependent on a single feature, the presence of oxygen in the vasculature, but is also dependent on the nature and characteristics of the ambient light reflected from that child, any other sources of ambient light in the room, blood loss or dilution of hemoglobin within the vasculature, and perhaps even a colour blindness disorder. Who knows? Because there is no experimental basis for making any such claim. And then he carries on. The witnesses, he argues, unjustifiably treated a wide variety of cutaneous discoloration as diagnostic. No, they didn't. They were very clever not to do that. They just mentioned it over and over and over again, rather like propaganda, so that it may as well have been diagnostic to a lay jury who doesn't truly understand what consistent with but not diagnostic of really means. What that phrase really means is that regardless of whether you see it or don't see it, find it or don't find it, it will make no material difference to your diagnosis. If something is not diagnostic, then it doesn't matter a damn if it's consistent or inconsistent, because consistent is the same as inconsistent. It would have been equally valid to tell the jury that skin discoloration was an inconsistent finding and not diagnostic of our embolism. Change one word round, consistent to inconsistent, keep the phrase not diagnostic, and you essentially mean the same thing. But how is a jury going to know that? The truth is, it is inconsistent and not diagnostic, and therefore it's useless. If it wasn't present, you could still have an embolism. If it was present, you may not have an embolism. That's what consistently inconsistent means. And Mr. Myers just carries on digging the hole, submitting that the prosecution expert evidence provided neither a research basis nor clinical experience sufficient to enable reliable identification of any specific cutaneous discoloration which would be diagnostic of our embolism. But what he should really have done was refer to Professor Kinsey's ludicrous notion that this skin discoloration was caused by blue blood, which is in the evidence here of the appeal court judges, but it doesn't actually exist. So the whole scientific premise for skin discoloration in the evidence here in this case is built upon a falsehood that in order to create this wonderful Lee and Tanswell rash, the baby needs to have blue blood, which doesn't exist. And in 137, the respondent, that's Mr. Johnson, submits that the judge's decision refusing the submission of no case no answer is unassailable. Mr. Johnson argues, as he did before the judge, that in relationship to each of the babies concerned, evidence relating to our embolism was only one part of the overall circumstances relied on as proving the prosecution case. He points to the evidence showing that each of the babies concerned collapsed or died for no apparent reason, that they exhibited skin discoloration of a highly unusual kind, often described by very experienced doctors and nurses as being unlike anything they had ever seen before, and that natural causes could not provide a credible explanation. But to me, it doesn't matter that these people said that they had never witnessed these type of skin discolorations before, because they described the type of skin discolorations, albeit in a very amateurish way. And what they described were pallor, white, erythema, red, cyanosis, blue, and livid purple, which are not unusual, and run the full gamut of all of the colours that the skin can take on for any reason. And they do have a credible, scientifically accepted basis for their existence. And it's more to do with the movement of blood in the circulation due to shock associated with underperfusion. That's the lack of oxygen in the blood. And it's very easy to understand. But that wasn't mentioned by Mr. Myers at all. Mr. Johnson adds another irrelevant matter. He adds that when the prosecution expert witnesses were preparing their initial reports, they did so without reference to other features of the circumstantial case against the applicant. And in a medical report, what's that got to do with anything? As I say, I've written hundreds of medical reports, and the circumstances of writing the report, the circumstances surrounding the report, were irrelevant to the medical information in the report. Did someone suffer a certain injury? Yes. Was that injury as a result of a traffic accident? Yes. Did it matter where the person was coming from or going to when the accident occurred? No. Did it matter what clothes they were wearing, who they were speaking to that night, whether they'd proposed to their fiancée that night, whether they'd looked up anyone on Facebook that night, or the day before, or were going to the day after? No, none of that matters to a proper medical report. What the expert witnesses managed to do was merge together so-called circumstantial evidence with expert medical evidence. And remember, every one of these babies had some form of metabolic acidosis. But instead of just mentioning that, the defense should have forced all of the experts to explain to the jury why that was so important. Is metabolic acidosis enough to cause the heart to fail on its own? Yes. Is there an agreed set point below which it will not cause the heart to fail? No. And for making claims like Bowen did constantly, that breathing fast was okay for a baby as long as it was stably fast, is such an outrageous lie that she and everyone else should have been hammered on that and asked for citations. And the defence could easily have had their own citations to read back to her in an open court to show that she was given evidence in bad faith or that she misunderstood. But the whole transcript is riddled with these inconsistencies. And carrying on to get through with this, 138, Mr. Johnson further submits that Dr. Jairam's evidence as to the discoloration which he observed on the skin of baby A, as noted in paragraph 51 above, could properly be accepted by the jury as fitting the description of the Lee and Tanswell paper. And the argument to that is, even if it was, Dr. Lee attributed, in other words, he guessed what the cause of that might be. But he has no evidential basis for his claim. And as I say, it could just as easily have been the opening and closing of blood vessels in the peripheries, which is a well-known and accepted and detailed phenomenon that easily explains these non-specific findings. Dr. Jairam had not initially mentioned seeing the discoloration he later described, and only did so after he had read the Lee and Tanswell paper. And again, that's wholly irrelevant. The Lee and Tanswell paper is, as we know, about pulmonary vascular air embolism and not venous air embolism. It was suggested to him in cross-examination that he had not in fact seen what he described. That suggestion was refuted by Dr. Jairam. And Mr. Johnson very easily says that the jury were plainly entitled to accept the doctor's evidence, that it was only when he read the Lee and Tanswell paper that he realised the full significance of the striking discoloration he had observed. And in paragraph 139, save that the description of skin discoloration did not feature in Dr. Jairam's clinical notes, we observe in passing that there appears to have been little evidential basis for the allegation implicitly made on behalf of the applicant that Dr. Jairam had made up this part of the evidence. We also note that no similar allegation appears to have been made against the father of baby O, who, as set at paragraph 93 above, described the child's veins as being bright blue. And this is now a very important mistake that Mr. Johnson makes. He is giving baby O's father's description of cyanosis an equal weight in evidence to Dr. Jairam's supposed Lee and Tanswell lookalike evidence. And unknowingly, I think Mr. Johnson has now reduced all the skin discoloration evidence to dust, because we all know now that Mark MacDonald is about to name the consultant who stuck a needle into the baby, quite literally, into the liver of baby O, and contributed to or may even be the likely cause of that baby's death. In paragraph 139 of the appeal court ruling, in other words, we bring together all of the skin discoloration evidence and we prove, by bringing it together, that it's utterly worthless when trying to determine a cause of death. All of it. Because it's the clear intention of Mr. Johnson in this argument to melt all of the different descriptions of discoloration into one pot, embolism. I hope he comes to regret using that strategy. And then in paragraph 140 we get to ground 2 discussion. So this is the appeal court judges. 140, we do not accept that the level of scientific knowledge concerning our embolism is so limited that no reliable expert evidence at all can be given about it. Our embolus as a cause of collapse or death in the neonate is not a bogus medical theory. The fact that our embolus can occur in neonates is not in dispute. Research is necessarily limited and the number of observed cases is fortunately small. And there are therefore limits to the extent of scientific knowledge on the topic. And that, too, is a grave error. But it does not follow that there can be no expert evidence as to whether an embolus did or did not occur in a particular case. But the judges, sadly, are wrong. They're ignoring the necessity of method by which to reach that conclusion, diagnosis in every particular case. And the expert witnesses' evidence is too far away from any standard needed to reach that conclusion. Indeed, it does not appear to have been disputed that the more than 50 cases reviewed in the Leigh and Tanswell paper were indeed all cases of embolus in a neonate. No, they were not. They were all cases of pulmonary vascular embolism in neonates. Grave mistake. The fact that embolus can occur and the imperative need to guard against it are well known, including to the applicant. Yes, that would be venous embolism, which is a different disorder to the Leigh and Tanswell vascular embolism, which presents differently and has a different prognosis and pathophysiology. The fact that embolus can occur and the imperative need to guard against it are well known, including to the applicant, and that would be venous embolism. Because since pulmonary vascular embolism, as explained in the Leigh and Tanswell paper, comes about largely because of prematurity, for the most part it isn't preventable. We agree with Mr. Johnson's submission that it is no doubt because appropriate precautions are taken that embolus in neonates is a rare occurrence. We don't actually know how rare it is. The number of cases reported are certainly rare, but all the articles say that we don't know what the incident is. Nonetheless, the nature of embolus, its possible causes, including the exogenous administration of its consequences and the biological mechanism by which it can cause death, are within the knowledge of general expertise of experienced neonatologists and indeed many doctors and nurses involved in clinical practice, something that we would have to agree with. But sadly, the nature of an embolism differs, and the expert witnesses don't seem to understand that, and therefore all the expert evidence about emboli given in this case is essentially junk science. It doesn't describe how embolism causes harm by many different means and methods, because it's singularly focused on presenting a biased interpretation of the evidence. And the judges carry on, so too are the signs and symptoms which will be found. Yeah, but 90% of the babies are on ventilation and have prematurity and central venous lines. And all Letby babies had CPR, rendering all of this evidence against Letby as pure junk. The judges go on, expert evidence can be given as to those topics, and such evidence may assist the jury to determine whether an embolus occurred in a particular case. And I have to argue that there wasn't enough explanation of how emboli come about and how difficult they are to diagnose and treat for a jury to reach any safe conclusion on the diagnosis of emboli in any of these babies. That's fundamentally the nature of this trial. And finally, although their direct clinical experience of our embolus in neonates was inevitably very limited, each of the prosecution's expert witness was well qualified in their respective fields to give the evidence which they gave. But sadly, that doesn't mean that the evidence which they did give was correct. And when we look at the literature, it's blindingly obvious that the evidence wasn't correct and that the jury were, in effect, misled. Paragraph 141, we therefore reject the applicant's attempts to exclude a substantial part of the prosecution expert evidence on the grounds that the state of scientific knowledge about our embolus in neonates is so limited that no expert evidence can be adduced about it. Wrong argument. There's more than enough expert evidence available to know that the evidence given in this trial is misleading. And 142, the real issue at the trial was as to what signs and symptoms were sufficient to enable a reliable diagnosis of our embolism. And that is a fundamental failing of the judges to understand how medical practice works. The very first thing we have to look at before we determine any pathology is the etiology or origin of the problem. Those findings of the origin would precede the diagnosis and long precede any signs and symptoms associated with the disease. And we have established in these podcasts through the citations that we use that prematurity and mechanical ventilation constitutes nearly all of the fatal air emboli in preterm neonates. We again observe the judges go on in the submissions to this court. It was at least tacitly accepted that cases noted in the Lee and Tanswell paper which showed a type of skin discoloration other than bright pink vessels against the generally cyanosed cutaneous background were indeed cases of our embolus. It follows that the differing types of skin discoloration observed in neonates in those cases were at least consistent with our embolus. Yes, but in the same way that fever is consistent with every infection. Can we determine the etiology or the origin and the diagnosis of infection from a fever, which is a non-specific finding? Of course we can. 143, we see the force of the argument that the limits of scientific knowledge would not permit a reliable diagnosis of our embolus to be made solely on the basis of a particular type of skin discoloration other than the very specific type recorded in the Lee and Tanswell paper. We are not, however, able to accept the submission that that is what the prosecution expert witnesses did. But even if they didn't do that, what they did do was wrongly describe how any embolism causes disease. In particular, Professor Kinsey's explanation is junk pseudoscience. Dr. Evans tells the court, which these judges have already told us in this ruling, that the air entered the peripheries, travelled all the way through the circulation, through the heart and into the lungs. Therefore, it can only have an effect from the lungs onwards. That effect would be primarily witnessed in the pulmonary bed. And not only can we not see the pulmonary bed, even if we could, we cannot detect the microscopic movement of oxygen using our eyes. What we can detect using our eyes that will explain all of the skin manifestations is the altered flow of blood due to shock from any cause. And any disease that causes shock can cause these skin discolorations. That's why we refer to the skin discolorations like fever as a non-specific finding. And non-specific means that we can't use it to make a diagnosis. That is literally what non-specific means. And then they go on to compound the mistake. In 144, they say paragraphs 49 to 97 above summarise the evidence as to skin discoloration observed in the case of the babies who are the subject of counts 1, 2, 4, 16 and counts 3, 5, 12, 17 and 20. So these are the air embolism and the expert evidence concerning these babies. As is apparent, there are recurring features. For example, the sudden and unexpected collapse of a baby who was otherwise reasonably healthy. Well, apart from the fact that they were not reasonably healthy, they were all on ventilation and they all had central venous lines or even peripheral lines. So the babies that they have just numbered all had pre-existing and well-known sources of air embolism. The dramatic and highly unusual changes in skin coloration and the coincidence of other babies who suffered sudden collapses, most strikingly in the case of twin siblings, but sadly premature twin siblings collapse suddenly at a much higher rate than preterm singletons. And they repeat again, as is also apparent. Neither Dr. Evans nor Dr. Bowen diagnosed air embolism in any case on the sole basis of skin discoloration. On the contrary, each expressly disclaimed any ability to do so in any of the cases they were considering. See, for example, the summaries of these witnesses' evidence in paragraphs 52, 54, 58, 59, 65, 67, 72, 73, 78, 81, 65, 88, 96, and 97. And in particular, Dr. Bowen's explicit acceptance in the last of those paragraphs that a wide variety of skin discoloration have been observed and that there is no one single thing that you can say is definitely pathognomic of air embolism. Their evidence that a particular baby had suffered an air embolus was in each case based on a combination of considerations, and I argue, at the heart of the problem, a disregard for all the other considerations that should have been taken into account. Yes, it may have been possible to say that all of these babies had air emboli, but it was not possible to say where it had come from. The careful submission of Mr. Myers did not identify any part of the evidence in which one of the expert witnesses asserted a diagnosis based solely on discoloration. And I asked you, the listener, to imagine what this case would have been like had there been no discussion at all of discoloration of the skin. Thus, it was not asserted that each or any of the varieties of skin discoloration seen in the babies concerned was diagnostic or pathognomic of air embolus. Rather, the expert evidence was to the effect that skin discoloration in each of the cases concerned was consistent with air embolism and, as I say, every other form of shock, making it a useless finding. The jury had to consider that evidence in conjunction with all the other evidence, including features which were wholly independent of the expert evidence, such as the fact that the applicant alone was present on the unit at the time of all the deteriorations and deaths. Did the judges really say that? Her keeping of handover sheets as what were said to be trophies, and her writing of notes said by the prosecution to include a confession to murder. 146. The premise of the submission of no case to answer is therefore in our judgment flawed. Right. You've had your medical education from Dowie Evans and Sandy Bowen, as did the jury. And we can chuck in a few more experts as well, which, as I've said before, is a Mickey Mouse medical education, and didn't leave the jury any the wiser about medical practice when they left that trial than before they started it. In our view, the applicant's argument confuses evidence capable of providing a freestanding diagnostic test and evidence consistent with air embolism, which forms part of the circumstantial case. No, the problem is that the circumstances themselves, that is, being in a neonatal unit and on mechanical ventilation and central venous lines, without any other consideration, explains the source of 90% of air emboli in preterm neonates. And therefore, in order to blame Lucy Letby for creating one, we have to explain away the 90% of the science of air emboli in the literature. 147, nor are we able to accept the submission on behalf of the applicant to the effect that the expert witnesses wrongly based the diagnosis of air embolism solely on an exclusion of other possible cases. That argument would carry more weight if any witness had given evidence to the effect that he or she could not identify any other possible cause of a baby's collapse, and therefore assumed on that basis alone that the baby's collapse must have been due to air embolism. Well, paragraph 147 just opens the door to Mark MacDonald as far as I'm concerned, because we are getting proper medical evidence that points to other likely causes of the collapses. And they say that evidence to that effect, that is diagnosis by exclusion, might well be criticised as mere conjecture. My argument from one doctor to another is that all of the diagnoses that Lucy Letby was supposed to have created were the result of mere conjecture. I agree totally. But the submission on behalf of the applicant did not persuade us that there was any instance in which either Dr. Evans or Dr. Bowen gave such evidence, when I would argue from a medical perspective that they did so in every case. They considered were appropriate whether the collapse may have been due to natural causes, but concluded for reasons which they explained that it was not. So babies don't collapse from losing half their lung to pneumonia, as both of these people said. They don't collapse from running out of dextrose or glucose, even though you have two central lines in the wrong place. Not one, but two. Babies who bleed to death don't bleed to death, according to these people. Babies with tachypnea and acidosis are stable, according to these people. People who have a catastrophic rupture of the liver from a cannula do not die suddenly. It's simply not true. Sadly, these things do happen. And their conclusion, for example, there could be no innocent explanation for their findings, as it turns out, is falling apart in front of us. But here's the clincher too. The defence were not able to point in cross-examination to any possible alternative cause which the witnesses found realistic. Does that statement mean the defence failed? The witnesses then identified findings which were consistent with, though not in themselves individually diagnostic of or embolism, like fever. Dr. Bowen largely reached the same findings as Dr. Evans, and it was plainly open to the jury to be sure that her evidence was an independent assessment and not mere uncritical endorsement of anything Dr. Evans had said. And I agree entirely with the judges here. They each gave their own version, and they need to be scrutinised as their own version. And they carry on. And in some cases, the evidence of other expert witnesses, in particular Professor Arthurs and Dr. Marnarides, provided an additional and separate basis for a diagnosis of her embolus. And I argue, no, it didn't. Plain X-rays and histology do not diagnose her embolism. And again, even if they do, they don't tell you where the error came from. Paragraph 148. In such circumstances, we are wholly unpersuaded that it could not properly be left to the jury to decide whether they were sure, on the basis of all the evidence, that the expert witnesses had rightly excluded other possible causes. Very important, as it turns out, had rightly relied upon a number of signs and symptoms, including but not limited to skin discoloration, which were consistent with her embolism and collectively inconsistent with anything else, and had correctly concluded that the babies concerned had suffered an error embolus. And in 149, Mr. Myers further submits that ground 6, relying on the proposed fresh evidence of Dr. Lee, is also relevant to this court's consideration of ground 2. We will return to ground 6 later in this judgment, but we should say at this stage that the applicant's argument on ground 2 cannot derive any support from the proposed fresh evidence. That is for the simple reason that ground 2 challenges the judge's ruling as to the sufficiency of the prosecution evidence which was before the court at the conclusion of the prosecution case. Any further evidence which might be received by this court cannot alter the evidential position which the judge had to consider. His ruling that the evidence gave rise to a case to answer cannot be challenged on the basis of evidence which was not before the jury and which was only obtained after the trial. And I think that's just a standard issue answer, isn't it? Which doesn't make sense in logic, but is obviously okay in the law. But again, it returns to this problem. How can a judge make a good judgment on bad evidence when he doesn't know what he's listening to is bad evidence? Paragraph 150, for those reasons, ground 2 is not arguable. Well, I've just argued it. 151, although it is not relevant to ground 2, we would add that the applicant herself, when giving evidence, raised the possibility of alternative explanations for the collapse or death of individual babies, but did not give affirmative evidence of any alternative cause. Well, she'll be able to do so now, that she has, could we say, a more learned considered and unbiased team of experts working on her behalf. And finally, thus the evidence as to the medical causation of each baby's collapse or death was the same at the conclusion of the trial as it was when the submission of no case to answer was made. Well, that clearly isn't the case now. Mark MacDonald is apparently, according to the Daily Mail anyway, getting ready to name the consultant likely responsible for the death of baby O. And this is evidence that was available to these experts at the beginning and the middle and the end of the trial. But for reasons unknown, these experts chose to interpret medical findings, particularly with regards to the stable nature of these babies, in a rather unconventional way, from one doctor to another, and with regards not to people, but to the practice of medicine and the use of science. And so we'll end it there. I find going through this stuff very tedious, and probably anyone who listens to it finds it tedious. But for the sake of completeness, we'll carry on until we finish this Court of Appeal ruling, so that no one can say to me that I didn't read it, because I've recorded myself reading it. And we'll start off the next episode with paragraph 152, ground 3, the judge's direction on harmful acts. So I'll see you in the next episode.